Judge Finkel, take it away.
Oh, okay, thank you. Hello, I'm Lester Finkel. I'm currently a judge at the Domestic Violence Courthouse, but for a number of years, for about 25 years, I did appeals for the Cook County Public Defender. But I note here, there's some names here I don't know, but there are some names here I see that I sit or stand in deference to their appellate abilities. Alan Spellberg, I see, is here, who was basically the appellate maven for the state's attorney's office for many years. And also, I see Alan Ackerman's name. I know that he is basically an icon of the field. And there probably are other people here who are, far more about appeals than I do. And I'll assume that either you're here because I'm very charming or you just need the CLE, one or the other. I'm not sure which one it is. But um, I'm just doing basically a tips for filing appeals, just very basic introduction to appeals that for some of you, you'll already be familiar with that. So let me go and share my presentation. There we go. And let me go into this with from the beginning. Let's see, did that work? Okay, I'm assuming that it is showing here. And like I say, this is just going to be basic tips for filing appeals. And I'll be going through this for approximately the next hour. So thank you for coming. And first, I want to have a disclaimer here. This is just a basic introduction to filing appeals. I mentioned some of the relevant rules, but not every rule, as well as the importance of preserving issues for appeal, for writing a concise and persuasive brief, and other matters. But this is not an end all or be all. This is not a substitute for knowing the rules. It is not a substitute for doing the necessary research. And my intent here is to go and first talk about some of the relevant rules, and then to talk about preserving issues for appeal. Then I'm going to go and address the workload of the appellate court. Then I'll be addressing my topic four. We'll be writing persuasively and directly. I'll then be transitioning to suggestions for a persuasive brief. And finally, some comments about oral argument. And again, if anybody has any questions, put it in the chat. But I'm also not averse to somebody speaking up. It's okay with me. I'm used to being interrupted. I'm interrupted all the time, and I've gotten quite used to that. So just to begin, the appeals in Illinois are obviously governed by Constitution and by Supreme Court rule. And first, Article 6, Section 4 of the Illinois Constitution, I presented it on the screen. I'm not going to read it for you. You have that in front of you. But it guarantees the right to appeal under the Constitution of Illinois as of right. And then also Article 6, Section 6, appeals from final judgments of the circuit court are as a matter of right to the appellate court in the judicial district where that circuit court is located. And that's very general, and more specific are the Supreme Court rules. And for many of you, this is just going to be a bit of a refresher. But as I put here, the rules governing appeals in general, and as well as the civil rules of appeals, can be found pretty much within Supreme Court rules 301 to 384. And the rules governing criminal appeals, for the most part, are rules 602 to 615. Then you have rule 651, which governs appeals for post-conviction cases. And then at the end of the 600s, you have appeals for under juvenile court. But I just want to draw attention to rule 612. 612 actually states that in about 15, I think 15 or 18 different categories, it is the 300 series of the Supreme Court rules that govern for criminal rules as well, because the necessity for a record on appeal, the necessity for a brief, the requirements for the brief, the page limitation, the word limitation, all of those are controlled by the rules under the 300 series, and they're simply incorporated into criminal appeals by Rule 612. So to begin, every final judgment of a circuit court in a civil case is appealable as of right. And I did have somebody, I'm assuming this audience knows better. I was talking about it with somebody recently, and they didn't understand the phrase as of right. But you have an automatic right to appeal under the Illinois Constitution, and that appeal is initiated by filing the notice of appeal. And likewise, in criminal cases, you have an appeal as of right under Rule 602. Now, Rule 603 provides the nuts and bolts for filing an appeal from a civil case. And the magic number here is 30 days. An appealing party has 30 days from the final judgment or from a ruling in a timely post-trial motion to file that notice of appeal. And that 30 days is not just jurisdictional, but it's sacrosanct. And here I would like to tell a little story about a case when I was with the Public Defender's Office. There was an individual who within that 30-day window, he had pled guilty, and we'll be talking about guilty pleas in a little bit, but he had pled guilty. And within 30 days, attorneys for another party contacted him and talked to him. And he then filed a motion to withdraw the guilty plea that he had entered previously, and he filed a motion to appeal. And it wound up going to with direction from the Illinois Supreme Court that 30 days was a period of time when nobody else should have been talking to that particular person other than his own lawyer, because during that 30 days, the representation by the lawyer continued. And that 30-day period of time, that lawyer had the responsibility to talk to the client, to ensure that the client understood everything, and to file the notice of appeal if the client wanted that notice of appeal to be filed. The form and the contents of the notice of appeal is set forth in Rule 303. And I'm assuming these materials are being sent out to everyone. So I gave the link to where you can find the approved forms for notice of appeal and other approved forms. They're available online. Rule 304 addresses appeals from final judgments in a civil matter that does not dispose of the entire case. And it gives a little explanation here that if not all of the parties or the claims are resolved, it talks about basically what is a final judgment. And in that case, the appeal can be taken only if a trial court has made an express written finding that there is no just reason for delaying either enforcement or appeal or both. So there has to be an express written finding if you have a civil case, for example, with multiple plaintiffs or multiple claims or multiple defendants, and then you wish to appeal from that. But only some of the plaintiffs or some of the defendants or some of the issues have been resolved. You can appeal from these, non-final judgments if it's final as to that issue. Again, I'm not going to be giving a whole lot of case law here. This is just a very basic introduction. And I'm expecting for people, if they wish to go and do the additional research, but I'm here just to go and give a basic template here for where the rules are. Rule 305 addresses a stay of proceedings while an appeal is pending. And there is a different set of procedures that are employed if the appeal is from a money judgment or if the appeal is from a non-money judgment. If the appeal is from a money judgment, there's a bond that has to be posted. And again, if you have an appeal of that nature, you have to read Rule 305. Then we come to the interlocutory appeals, which are Rule 306 to 308. And there are interlocutory appeals by permission and interlocutory appeals as a matter of right. And I've listed, as you can see here, there are 9 different categories for interlocutory appeals by permission, which means that you may want to appeal, but you don't have the automatic right to file that appeal. You have to ask for leave to appeal to the appellate court. If you have, for example, an issue involving forum nonconveniens, which is issue number 2, you have to ask for permission. May I file this appeal? And the appellate court can say yes, the appellate court can say no. And again, I'm not going to read all of this material for you. Number 5 is an appeal that often comes up in the child protection area. So 306.5 concerning interlocutory appeals affecting the care and custody of or the allocation of parental rights. And many times there are appeals there where the judgment is not final, but the case is continuing. Parties can go and ask for permission to file for an appeal, even though it hasn't been resolved yet. Again, you would have to check the rule and check the case law on that. Disqualification of an attorney for a party. That is something that can also be an appeal by permission. Denying or granting certification of a class action, so forth and so on. Then we come to Rule 307, interlocutory appeals of right. And this is of right when there's an injunction involved, when there's a receiver involved, as you can see, issues involving mortgagee in possession of mortgage premises, appointing or refusing to appoint a receiver, terminating parental rights, or granting or revoking temporary commitment, and also determining certain issues in eminent domain proceedings. Rule 308 allows an appeal based on certified questions from the trial court, and to be a valid certified question, as I put down here, a trial judge must find that the order involves a question of law, and this language is from the rule, and I actually had a few appeals on this ground. I never got an appeal based on a certified question, by the way, just so you know. I admit my own deficiencies here. But the trial court must find that the order involves a question of law as to which there is substantial ground for difference of opinion, and that an immediate appeal from that order may materially advance the ultimate termination of the litigation. It's both. There's a conjunction there with the word and. There not only has to be a substantial ground for difference of opinion, but it has to, whatever the appeal is being taken from, has to materially advance the ultimate termination of the litigation. So even if there's a great deal of difference, even if there's confusion in the lower courts, that is not going to be granted an appeal based on a certified question, and the appellate court will turn it aside unless that appeal can materially advance the ultimate termination of the litigation in that case. The rules continue to talk about pre-hearing conferences and settlement conferences, which can be requested on appeal. Rule 311 talks about accelerated appeals. Child protection cases, for example, are on an appellate accelerated docket in which the brief has to be filed within 21 days, and they have similar accelerated timeframes for filing the appellee's brief and the reply brief. Rule 312 lays out the required elements for a docketing statement. And then Rule 313 talks about the fees in the appellate court. Again, as I say, I keep repeating here, I'm just touching on the rules and I'm not delving into it, but if there are questions, please ask. The rules governing the preparation of an appellate record, there are many of them. Rule 321 talks about the contents of the record on appeal. Rule 323 talks about the report of proceedings. Rule 324 is the certification of the record on appeal. And as you can see, the following rules are on transmission of the record on appeal, the time for filing the record on appeal, the notice of filing the record, the supporting record, supplemental record, captions, and return of the record. But I want to take a moment to talk about the contents of the record on appeal, because you have to remember, and I have a case at the very bottom of this slide here, it is the appellant who always has the burden to present a sufficiently complete record. If there is something missing from the record on appeal, then it's going to fall on the appellant's attorney as far as a claim that that attorney didn't do everything possible to preserve the issue for appeal, to raise it before the appellate court. If there is no transcript, the attorney may be required to try and recreate a transcript or create a bystander affidavit. If there is no notice of appeal contained in the record on appeal, that's going to be a problem that the appellate court may say that we don't know when the judgment was entered and when the jurisdictional requirement for filing the notice of appeal was filed. But the record on appeal has to have every document that was in the common law record. And if there is a report of proceeding, it has to have all of those transcripts that were prepared during the course of the trial or hearing or proceeding below. Rule 341 then governs briefs. And I've seen attorneys who forget. Most attorneys are used to paper being 1-inch margin all the way around. But for an appellate brief, the left side margin has to be 1.5 inches. The other margins, the top right and bottom, can be 1 inch, but the left hand has to be 1.5 inches. The typeface has to be 12-point or larger. And briefs have a maximum length of either 50 pages or 15,000 words. And there is a requirement now to include a certification of the length of the brief at the end of the brief. So if you're doing a word count on your brief, you have to use your word processing program, probably Microsoft Word, to tell you how many words it is, not counting the cover page, not counting the points of authorities, and not counting certain other areas of the brief that are specifically laid out in Rule 341. And you have to identify how many words that brief is. And for people who are not aware of it, the word requirement was instituted when it was discovered that some people were fudging a little bit on the pages. People would be fudging on the margins. They would fudge with the typeface because, as you may know, 12-point Times New Roman takes up a different amount of space than 12-point Calibri or 12-point Arial. And you could play around, in a sense, with the fonts and with the margins in order to try and squeeze out more text per pages. But 15,000 words are 15,000 words. Although I do know, and I have heard, that some attorneys have used hyphenated words, and Word, Microsoft Word in particular, from what I've been told, recognizes a hyphenated word as a single word. But still, it's a way to go and maintain a certain cap, maximum limit on the length and size of a brief. Rule 351, Rule 341 also explains in great detail the parts that have to be in the brief following the cover page. So you have your table of contents, you have your points and authorities, you have an introductory paragraph stating the nature of the action and the judgment being appealed from. You have to say in that nature of the action whether or not there is a question being raised on the pleadings. Is this an issue, for example, on a motion to dismiss, where there's a question on the validity of the pleadings? You have to identify that in your nature of the action. You then have a statement of the issue or the statement of issues that are presented for review. You have to include a statement of jurisdiction. If you have a statute that's under construction, a constitutional provision under construction, a treaty that's under construction, you have to provide the pertinent sections of it, either in that section there or in the appendix. So if you were relying on a particular statute, if the statute is too long to include within that front part of the brief, within that section of the brief where it says, constitutional or statutory provisions, then include it in the appendix. But if it's a short, relatively easy cut and paste from the Constitution or from a statute or from an ordinance, you should put it in that section. Then you have the statement of facts with appropriate reference to the pages of the record, followed by the argument and followed by a short conclusion stating the precise relief being sought. And then, of course, as the rule says, names of counsel have to be on the last page there, just as they are on the cover. And then that's followed by an appendix. And speaking of appendixes or appendices, Rule 342 sets forth what the appendix has to contain. Rule 343 governs the time for filing and serving all briefs. Rule 352 governs the conduct of oral arguments. And Rule 361 governs motions in the appellate court, while rehearing petitions are governed by Rule 367. And again, I repeat, I'm just touching on these rules, but if there are questions, I can go into more detail with them otherwise. But going back to the appendix is basically sort of another table of contents for the record on appeal. Whereas you had a table of contents for the brief at the beginning, this is the table of contents for the record. Because the table of contents, the appendix has to first contain a table of contents of the appendix itself. So you have to say what is in that appendix. Then you have to include a copy of the judgment being appealed from. You have to include in that appendix any opinion, any memorandum, any findings of fact. You have to include any pleadings that are relevant to the appeal. You should include a copy of the notice of appeal. And then yet another table of contents, you have to include a complete table of contents of the record itself on appeal, where every document is in that pleading. Now, the longest appeal that I ever had was approximately 4,000 pages. And the table of contents for the appendix and the table of contents for the record on appeal itself probably came to 40 or 50 pages. But it is necessary because it's required by rule. Regarding this last requirement about the complete table of contents with the page references, went forward there for a second. That table of contents for the record on appeal has to identify every document that's in the record. Where there are pleadings, motions, or other documents, It has to reflect what date was that document filed or what date was it entered. And for the report of proceedings, where did each witness testify? What is the witness's name? On what page does their direct examination begin? On what page does their cross-examination begin? What page does their redirect examination begin? Because when you're asking the appellate court to rule in your favor, you have to help the appellate court justices see everything and read everything that is there. And it basically provides an index or a table of contents for the record so that the justices can find what it is that they're looking for. Now, I want to take a moment to talk about standard of review. Rule 341H. Now, Rule 341 talks about the requirements for a brief, but subsection H says, quote, an appellant must include a concise statement of the applicable standard of review for each issue with citation to authority, either in the discussion of the issue in the argument or under a separate heading placed before the discussion of the argument. I don't know that there is any right way to do it. Some people will include the standard of review within their argument. Some people will put the standard of review in advance of the argument. There's no right way in that department. There's no wrong way with that department. But just so that you remember, I think I have it here somewhere. I might have had it later. But I just want to talk about standards of review. You may remember those standards of review from law school. And just to remind you, the three most common standards of review, and I think I have a slide about this later, are clear error or manifest weight of the evidence, abuse of discretion, or de novo. And by the way, if I ever get a pet, I don't have a pet, but if I do have a pet, I'm thinking of naming my pet de novo. Wouldn't that be a cute name for the pet? So just a thought there. But as you may remember, de novo review means of the new. So that means that the appellate court doesn't have to show any deference at all to what the trial court did or what the trial ruling was. Because de novo review is reserved for issues basically that are matters of law, construction of the words of the statute, constitutional issues. What does a particular phrase mean as it's used in a legal context? And a decision by the trial judge, it's not binding on the appellate court because the appellate court is in as better or a better place, as good or a better place to go and decide what the law should be and how a statute should be interpreted than a trial court is in that position. The appellate court can do that, and that's where de novo comes in. Now, for clear error or manifest weight of the evidence, that would be your classic case, for example, of in a criminal case where a jury says that somebody was found guilty, criminal defendant is arguing, no, I wasn't proven guilty beyond a reasonable doubt. Or in a civil case, a party loses and they want to appeal to say, no, I should have won by a preponderance of the evidence. Either way, there has to be clear error, and that is the most deferential method of review. So because that involves issues of credibility of the witnesses, the judge or the jury has listened to the witnesses, has viewed the witnesses, has made a decision on believability and credibility of those witnesses, and that is not going to be overturned unless it is clear error. In fact, again, I tell some stories here, and my stories tend to be criminal law stories because I was a public defender doing appeals for 25 years. I had a case in which there was an individual, he was charged with a sexual assault. He was convicted of the sexual assault, and I had it on appeal. But what had been elicited during the trial was that at the time of the sexual assault, he was in the Navy, stationed in San Diego on a ship. It was introduced that they had a head count on the ship every Sunday. So he was there on the Sunday before the sexual assault occurred. He was there on the Sunday after the sexual assault occurred. In both instances, he was not AWOL and he was there. The state's theory was that, oh, this sexual assault happened on a Wednesday. He could have come back to the Chicago area. He could have committed the sexual assault, gone back to San Diego in time. And simply because he was on the boat on the Sunday before and the Sunday after does not prove that the identification of the witness was incorrect. does not prove that it was necessarily wrong. I argued on appeal that, oh, it was not likely, that he was not proven beyond a reasonable doubt of his guilt. But the appellate court went and they examined it using the standard of review. And they said, we are not going to reverse unless it is against the manifest weight of the evidence, unless there is clear error, unless no reasonable judge or jury could have found those facts. And so they said the jury heard the evidence. They made the determination. It was a possibility that he could have come back to Chicago and left again. So the conviction was affirmed. So if I had had de novo review, might have been a different story. But no, I had manifest weight of the evidence as my standard of review. And the third most common standard of review that's used on appeal is abuse of discretion. And abuse of discretion applies to almost every single evidentiary ruling that has ever been made in court, simply because judges have to use their discretion every single day. They have to make these determinations. What should be admissible, what shouldn't be admissible. And a ruling either way may be right. The judge could rule to admit evidence. The judge could rule not to admit evidence. Either ruling may be supportable. The question isn't whether or not the decision was right or wrong. It was, did the judge properly use his or her discretion? And that is also a difficult burden to overcome. But you have to remember, if you can use the standard of review in your favor, if you can convince, if say you have a novel issue or an issue of first impression, and you're able to find a standard of review that works to your advantage, you should do so and you should make that argument. And I cite to a case, what was that? Keohane versus Thompson from the United States Supreme Court, in which the whole issue was the standard of review. And in Keohane, they cited to another case called Ornelas versus United States. And both of those cases talked about that sometimes in an appeal, the standards of review are twofold, and they are a mixed question. Because sometimes, for example, if somebody is appealing a pretrial motion, the findings of fact should be reviewed for clear error, and therefore they're entitled to deference. But the legal conclusion, the ultimate ruling, might be a legal ruling, and that should be reviewed de novo. So it might be worthwhile if somebody wants to go and take a look at either Keohane or Keohane or Ornelas. I'm taking a look here to see if anybody was chatting. So next, there are special appellate rules. Rule 604A governs when the state can file an appeal in a criminal case, and the state is pretty much confined to that. Now, there are many requirements that the state has to go through, but the state has that ability. Well, as I said, I noticed that Alan Spellberg was here. He would know that 10 times better than me, and I give deference to him. Rule 604D governs appeals from guilty pleas in a criminal case. And an appeal may not be taken from a guilty plea unless, as it says here, the defendant within 30 days of the date on which the sentence is imposed files in the trial court a motion to reconsider the sentence. Or if the sentence is being challenged, or if the plea is challenged, a motion to withdraw the plea of guilty and vacate the judgment. Now, I don't know if we have any federal practitioners here. I'm aware that in federal court, a party can go and enter basically a guilty plea with a reservation to permit an appeal on a legal issue. That is not the case in the Illinois courts. In the Illinois courts, if a person is pleading guilty, he's waiving the issues. And if he wants to file an appeal because of some underlying issue, perhaps that was resolved at a pretrial motion, or if he wants to file an appeal because of his sentence, he has to ask to either vacate the sentence or vacate the guilty plea. That is a jurisdictional requirement under Rule 604D. Then 604H, which is one of the newer appellate rules. Formerly, we had 604C, I believe it was, which governed appeals from bail hearings and setting bond. But now Illinois, as you know, no longer has cash bail, and we have detention hearings. So 604H talks about appeals from orders imposing conditions of pretrial release or denying pretrial release. And as a predicate to filing this type of appeal, the party appealing must first present to the trial judge a written motion requesting the same relief being sought on appeal. So if you're asking for release, or you're asking for the elimination of certain conditions, such as electronic monitoring or GPS, then you have to file a written motion in front of the trial judge first before you can make that argument on appeal. And then further, as I put in the quote here, any issue not raised in the motion for relief, other than the errors occurring for the first time at the hearing of the motion for relief, shall be deemed waived. So again, this goes to the issue of preserving issues for appeal and making sure that you make a record so that the appellate court has the material in front of it to make an intelligent ruling. At this point, I want to talk about the necessity for making sure that the appeal is timely filed. The notice of appeal must be filed within 30 days, and this is a jurisdictional requirement. Whether you are in civil court or criminal court, if you file that appeal after 31 days, that's a problem. There are ways to try and get around it, but it's still a problem. For criminal appeal, the question arises, and this arose many times when I was in practice, who has the duty to file the notice of appeal? The duty to file the notice of appeal in criminal cases generally falls on defense counsel. And there's a case, Roe versus Flores-Ortega, which they said that an attorney who fails to file the notice of appeal, once the attorney is aware that the client wants to appeal, that attorney has provided ineffective assistance of counsel. So trial attorneys cannot go and say, well, I finished the trial, I'm washing my hands of it, and I'm done. That is not an acceptable answer. The trial attorney has the obligation to file the notice of appeal for that criminal client. And in fact, I have a quote here from the Flores-Ortega case in which they talked about that counsel has that duty to consult with the defendant about an appeal when there is reason to think either that a rational defendant would want to appeal or that this particular defendant reasonably demonstrated to counsel that he was interested in appealing. So I don't know if there are any criminal practitioners here who are watching this live or watching this on video, but if a client contacts you on day 29 and says, I want to appeal, even though you may have told him, we weren't going to get anywhere with this trial and you don't have any good grounds for an appeal. If the client has demonstrated to counsel that he wants to appeal, the attorney has the obligation to file that notice of appeal for the client. And in addition, if a criminal defendant doesn't even say anything, if a rational defendant would want to appeal in a situation, then that notice of appeal should be filed. And that is constitutionally imposed on criminal defense counsel. In fact, to the point that the Illinois Supreme Court in People versus Ross said that post-conviction relief can be granted if trial counsel failed to file the notice of appeal. So a post-conviction judge can order that a criminal defendant be granted his day in appellate court. In civil appeals, the duty to timely file the notice of appeal rests on the party or their attorney. There is no constitutional requirement because civil cases are not governed by the Sixth Amendment, but the party or their attorney has that responsibility. And I provided the quote here. This was a case in which the attorney claimed that he had been told by the circuit court clerk that the clerk would take care of filing the appeal. You can't rely on that. It was the party and the attorney who had that obligation and responsibility, as it says here, to check and verify that the notice of appeal was filed timely. And as the court wrote, while the circuit clerk might desire to be accommodating, there is no duty imposed by simply sending a letter such as this, and they were referring to a letter that was over there. It is still pretty much the attorney's obligation. Now, there is no Sixth Amendment violation here, but a civil attorney who has promised to file the notice of appeal and does not do so may be opening himself or herself up to claims of legal malpractice. If an appeal is late, though, late appeals can be filed, but they're filed by permission. For criminal appeals, Rule 606C says that the appellate court can be asked within 6 months after the due date. So if it's January 1st and the appeal was due by January 30th, which would be 30 days later, or would it be the 31st? Maybe the 31st. So 30 days later would be January 31st. If that appeal was due 30 days later on the 31st, but it's late, then for 6 months, If there is a good reason given, and an affidavit must be presented with a motion to the appellate court. If a good reason is given, then the appellate court has authority under Supreme Court Rule 606C to go and grant permission to file a late notice of appeal. After 6 months, though, even the appellate court does not have jurisdiction. And if you should happen to be in that position, that you have a client who you thought there was an appeal filed, this is a criminal case, you thought there was an appeal filed, and it turned out it hadn't been filed, and 7 months, 8 months, 9 months have passed, your option is simply to go and file a petition for supervisory relief to the Illinois Supreme Court, because the appellate court no longer has authority to grant or allow a late notice of appeal. But the Illinois Supreme Court does have that authority. And when I was with the Public Defender's Office, we had cases where the appellate court, because of misconduct by the attorneys below, I've seen them grant late notices of appeal up to 3 years late. In civil cases, it's Rule 303D that controls. And in that, there has to be a motion supporting a show of reasonable excuse filed within 30 days, not 6 months, but 30 days after the expiration of the time for filing. The reviewing court may then grant leave to appeal. After 30 days, the appellate court loses jurisdiction. And again, if you need to file a late notice of appeal for your civil client, after 30 days, you would have to go and file a motion for supervisory relief to the Illinois Supreme Court. Now I want to go on to the next topic. Having covered the rules, I'll go briefly, as I say. You have to remember that the appeal starts with preserving issues at trial. And for that, I have an example from civil law and criminal law. But first, let me talk about the Illinois Rules of Evidence. Rule of Evidence 103B actually lays out that in both civil and criminal trials, a contemporaneous trial objection or offer of proof must be made to preserve a claim of error for appeal. In criminal cases, the contemporaneous, as it says here, once the court rules, a contemporaneous objection or offer of proof doesn't need to be renewed to preserve the claim, but there has to be the objection. However, in civil cases, even if the court rules before or at trial, a contemporaneous trial objection or offer of proof must be made to preserve the claim of error for appeal. Remember, a good appeal starts with a good trial, and the good trial involves preserving issues for that appeal. And then I want to emphasize paragraph 4 of Rule of Evidence 103B. In all criminal trials and civil jury trials, a claim of error must be made in a post-trial motion to preserve the claim for appeal. Such a motion is not required in a civil non-jury trial. So unless there's a contemporaneous objection, and for criminal trials or civil jury trials, unless there is a post-trial motion filed, you have likely forfeited that issue for appeal. But such a motion, as it says here, is not required in civil non-jury trials. And I have 2 cases here as an example, a criminal case and a civil case. And in the criminal case, it was a case from the Illinois Supreme Court. Johnson was 17, his girlfriend was 14, and he was charged with criminal sexual abuse. The jury sent out a note, they were deadlocked, and without waiting for counsel, the judge told the jury to keep deliberating. The defendant was then found guilty. Defense counsel didn't object to the judge's response. On appeal, counsel argued that the judge answered the note without counsel or Johnson present. The appellate court reversed, but the Supreme Court reinstated the conviction. Why? Because the defendant didn't object to the error at trial and didn't include the error in a post-trial motion. He therefore forfeited the issue. And all he had left to argue was that there was plain error. That was it, nothing else. Same concept, though, goes in civil cases. This is Spurgeon versus Maroons from 2005. There, a jury found in favor of a defendant doctor in a medical malpractice case. The plaintiff argued that the trial court erred in barring the defendant's expert witness from testifying, but the judgment was affirmed because there was no specific objection and no offer of proof made. And I have a quote here from that case. In civil matters, a party must make a timely objection to preserve an issue for appellate review. And a party who, prior to trial, unsuccessfully moves to bar certain evidence must object again to the evidence when it is offered. Although the plaintiffs filed their motion in limine, they did not renew their objection. Therefore, the issue was lost. It was forfeited. In criminal cases, an issue that is not properly preserved for appeal can be considered if it's deemed plain error. Now, that does not necessarily apply in civil cases, but with plain error, it becomes the burden of the defendant to show that the error was prejudicial on appeal. And this is taken directly, this is a quote taken from Illinois Supreme Court Rule 615, which talks about plain error. That's a clear or obvious error where the evidence is closely balanced, or a clear and obvious error that is so serious that it affects the fairness of the defendant's trial and challenge the integrity of the judicial process. Federal plain error generally looks at the structural integrity of the trial and whether the structural integrity was compromised. There was a case in Illinois, I believe it was People versus Nakia Heron, in which the Illinois Supreme Court considered whether to modify Rule 615 and have plain error mimic and follow the same kind of structure that the federal plain error rule has, in which case the closely balanced nature of the error would not be an issue, and it would only be, plain error could only be recognized by the appellate court if it was a serious error so significant that it affected the integrity of the trial. The Illinois Supreme Court rejected that and maintained this two-pronged way of analyzing plain error in criminal cases in Illinois. In civil cases, Illinois Rule of Evidence 103E, it does state, quote, nothing in the rule precludes taking notice of plain errors affecting substantial rights, although they were not brought to the attention of the court. But it is almost never used. And I found this case from 2010, Wilburn versus Cavallanis, in which the plaintiff complained on appeal of prejudicial remarks made by defendant's counsel, but the plaintiff objected only to the comments made during the closing argument, never raised it in the post-trial motion. And remember, if it's a jury trial, it has to be raised in a written post-trial motion. I have this quote here. I'm not going to read all of the quote to you, but the essential elements is the plain error doctrine, as they say, finds greater application in criminal cases and is applied in civil cases only when there was a prejudicial error so egregious that it deprived the complaining party of a fair trial and impaired the integrity of the judicial process. Because the Sixth Amendment doesn't apply in civil cases. So therefore, plain error is a much, much harder road to take when you're dealing with civil cases, if it has not been preserved below. Much more easy to go and dispense with that kind of issue in a civil case for the appellate court. So here's my one graphic. I apologize for all the words that I have here. I am not a proficient person or expert with PowerPoint. I don't know how to make things move around on the screen or animate things. I wish I did. I wish I was more animated, but this is my one little graphic that I have here. So you need to object and you need to include the issue in a post-trial motion, or else the odds are that your issue will never be recognized by the appellate court and it will be considered forfeited. And why do these rules come into effect? Well, I want you to consider the number of cases received by the Illinois appellate courts every year. And these are the statistics, the most recent statistics from the Administrative Office of Illinois Courts. As you can see, the most recent statistics are for 2024. I just want to look at the cases disposed. So in 2024, there were 1,416 civil appeals disposed by ruling by the appellate court first district. This is just the first district. And there were 1,075 appeals disposed of, again, by the first district. That's over 2,400 appeals. Actually, I added up later. That was 2,493 decisions that the appellate court issued during 2024. And remember, Cook County, which is the first district, has 24 appellate justices. So that means that each justice had to do 104 decisions per justice. That's 104 sets of briefs. And keep in mind that each set of brief, for the most part, are 3 briefs. You have the brief by the appellant, you have the brief by the appellee, and then you have the reply brief. So that's 312 briefs. I'm sorry, actually, I'm speaking ahead of myself. It is 3 sets of briefs, but each justice, my point here was that each justice sits as part of a panel of 3 justices. So even though going back for a second, even though each justice may be responsible for authoring 104 decisions, each justice sits on a panel of 3. So each justice is ruling on average, 312 appeals during the course of the year based on those disposition records, which means that judge has 312 briefs, sets of briefs that the judge has to read, that the justice has to read. And each set is 3 briefs. So that's 6 sets of legal briefs each week, 18 individual briefs every week for 52 weeks. Imagine the amount of time that is spent reading by the justice, by the justice's clerks. All the downtime is spent. You don't have the luxury of simply reading it in a mahogany-covered reading room. You have to read where you can, when you can, in order to keep up with the volume of those appeals. And as I say here, if you follow the rules, the notice of appeal has been filed timely, the record has been filed timely, and you're ready to file your brief, now comes the time to make your brief persuasive and to explain why you should win. And if you consider the number of briefs that justices have to read, if you consider for yourself, if you had to read 312 sets of briefs every year, you would not want people to run on and on and on. You would want them to get to the point. You would want them to be persuasive. You wouldn't want to have legalistic arguments, arguments that contain double and triple negatives. You wouldn't want circular or convoluted arguments. You would want direct, simple, persuasive, and succinct arguments. Just like in a trial, have a theme to your appellate argument. Consider the issue. Consider if it's direct and understandable. Set it down. Look at it with fresh eyes. Have somebody else take a look at your brief, somebody who doesn't know the issue. Do they understand it? Consider whether your argument asserts why you should win, not why the other side should lose. Because I've seen many, many briefs over the course of my time, some written by me even, in which the primary argument was not why I should win, but why the other side's argument was weak and should lose. That's a defensive argument. You should argue why you should win. You should be in favor. You should put your foot forward and be affirmative in your argument, not be defensive and take a step back as to why the other side's argument isn't as good as they thought it would be. Yeah, and you should have a theme. And for the theme, I want to point out these 2 cases that were separated by a few years. In Bowers versus Hardwick, 2 men were arrested for having consensual sex with each other. Supreme Court case. They were charged with violating Georgia's sodomy statute. And the court in Bowers was asked whether sodomy violates a fundamental right of a person arrested. The court ruled that there was no fundamental right to engage in sodomy. 17 years later, Lawrence versus Texas came around. 2 men were arrested for having consensual sex. Exactly the same core facts as in Bowers versus Hardwick. But here, the issue wasn't whether the state can criminalize sodomy. The issue, as phrased in the opinion, was, are adults, consenting adults, free to engage in private conduct in the exercise of their liberty under the Due Process Clause? If you took a survey of people and you said, are you in favor of sodomy? Most people would say no. If you say, are you in favor of private conduct in your own home, liberty and due process, most people would say yes. What changed between Bowers, from Bowers to Lawrence, was how the theme was presented, how the issue was presented. In Bowers, as I say, Georgia made the more persuasive argument, and they controlled what the theme of the appeal was. But in Lawrence, the petitioners made the more persuasive argument because they controlled what the theme was, that it was liberty and privacy. If you control the theme, then you will take a large step in winning your appeal. And that involves emphasizing the facts in your favor, not ignoring bad facts, but emphasizing the facts in your favor, explaining or de-emphasizing the facts if you can by putting bad facts in context. But you use those facts in your argument and weave them in to your particular case with comparable cases and the facts on appeal. So now I'm switching to, and I see I've only got 10 minutes left, so I'm switching to general recommendations for an effective brief. Know why your client should win. If you cannot articulate why your client should win on appeal, then you are not going to have a successful appellate brief, and you're not going to be persuasive. If you can't convince yourself, you're going to be unable to convince others. but you want to present it in a compelling fashion to show why justice is on your side and to convince the justices to rule in your favor. Know the standard of review, and as I mentioned before, de novo, abuse of discretion, and clear error. Use that standard of review to your advantage. Try to structure your brief around a theme, just like you. I assume there are trial attorneys here, just like I'm sure you have a theme at trial. You should have a theme for your appeal. Know your authorities. If the appeal depends on a statute, the interpretation of the statute, you should know that statute backwards and forwards. You should include it in the appendix. If it depends on the interpretation of a higher court case, know that case backwards and forwards. Start, as I say, put your foot forward. Start with cases that support your position. Don't start with cases that you have to distinguish. It's always weaker when a party starts with a case to say, well, this is the leading case in the field, but it doesn't apply. That puts you on the back foot. That makes you defensive. Make sure that your brief is readable with transition sentences or subheadings, what I call signposts, to make sure that the justice is reading this. Understand when you're moving from one aspect of your argument to the other. And then, as I say here, edit your writing, edit your writing, edit your writing. If there's anybody who thinks that he or she can write a persuasive argument first time through, I would like to meet that person. I did appeals on a daily basis for 25 years. I was never able to write anything well written the first time through. I had to edit. If I wrote my facts first, and then I would have to go back to my facts after I did the argument. If I wrote my argument first, I would have to go back to the argument after I wrote the facts, because each side depends on the other. And I would make sure to give myself enough time to set whatever it was I was writing, set it down, wait an hour, wait a day, go back and look at it, because you would be amazed at how many times you look at something after a period of time has passed and you see mistakes you never saw before. I have a particular tendency that don't know why, but instead of typing from, I type form. And so I have form. I don't see that the first time through. I'll see it the second or the third time through, but not the first time. Be direct, succinct. I think everybody here has heard of the acronym KISS, and I obviously put it in there. But also be honest and show your integrity. If a fact is bad, admit it. Explain why it doesn't hurt you, but admit it. Because if you hide back bad facts, you lose your credibility. And now, just to have a few words about appellate argument. I checked the statistics, and according to the Administrative Office of Illinois Courts, oral arguments are granted in approximately 20% of all appeals. So most appeals don't have oral argument in the Illinois courts, in the Illinois appellate courts, I should say, not the Illinois Supreme Court, where each appeal gets an oral argument for the most part. But the oral argument is where you get to interact with the justice. While you're writing the brief, think about what questions someone might have for you, because the more you anticipate, the more persuasive you can be. As you get ready for oral argument, read your cases, know your opponent's cases, know the facts, know the law, know the strong points and the weak points. Have people mock you. Have people do little moot arguments with you to test your ability to know your argument, because there is nothing like a real world practice to get you ready for it. I know when I would go and do arguments before the Illinois Supreme Court, I had 10 of them, which in the scheme of things probably isn't that much, because I know that there are other advocates who've had many, many more arguments. But when I had 10 of them, I would make sure to have at least 2 practice sessions, 2 moot courts before I went down to Springfield to do my argument. When you get up to that lectern, don't read your argument. I noticed before, I think that I said Alan Spellberg was here. I have great admiration for Mr. Spellberg, and I've seen him do oral argument. He doesn't bring a single note up to the lectern, because the more notes you bring, the more you're going to fumble with the paper. And that's going to go and make you feel uncomfortable and make you feel awkward and make you feel awkward to the justices. It's okay to have notes as long as they're organized, as long as anything that you need can be found easily. Don't worry about finding the perfect answer, but as long as you have the answers available just from a glance at your notes, that's great. Remember, if you're asked a question, answer yes, Your Honor, no, Your Honor first, then give your more complete answer. Listen to the questions being asked of you. Listen, take a moment. It's better to pause than to speak first without thinking. And then when you're done, you can ask, thank the justices, and you can, as I say, bask in a job well done. So with that, I know that I rushed through this, but I did have some material. With that, I believe I have 4 minutes left on my time slot. So I hope that Ms. Pat appreciates that I've covered the hour. And I don't know, let me look in the chat. Was there a question? No, there were no questions. So,
Oh, Your Honor, I have a question.
sure, go ahead.
Okay, good afternoon. It's good to see you again. I think you mentioned that when you're drafting a brief to not um basically knock down the other side's argument and focus on yours.
No,
Um,
I didn't say, I'm not saying don't knock down the argument. I said you begin with your strength. Don't begin. My focus was how you begin. Many times I had seen people begin their argument by saying how appellee is wrong. No, begin by saying I am right, whoever the I is. Begin by putting forth your position, then go and distinguish the cases of the appellee, the other side. Or if you're the appellee, show why you're right first, and then distinguish the cases of the appellant. Because if you start by knocking down the other side, the first question is, well, why aren't you telling me why you should win first? So I'm going to distinguish how you phrase your question a little bit. That is what, if I didn't articulate it well, I'm sorry, but my point is, yes, you can distinguish the cases, but you put forth your position first. Does that make sense?
Absolutely. Thank you for distinguishing my question. That absolutely makes a lot more sense. And then piggybacking off that, sometimes trial judges like us to bring Rule 23 orders to them just to be, I'd be remiss if I didn't share this with you. For the appellate court, they don't need any such help. Is that my understanding?
Well,
Or guidance, as some judges call the Rule 23 orders, or guidance.
well, there's true Rule 23s and there's not. As you know, once upon a time, I think it was before 2011, Rule 23s were all unpublished and they were considered not persuasive. Now, if it's considered technically, if it's a Rule 23 summary order, it is not persuasive at all and shouldn't be used. If it is, however, a Rule 23 order that has the universal citation dash U after it, it can be used, but it's according to the Supreme Court rules, it is persuasive authority but not binding authority. So if you have, say, a first district opinion that is a U case, which would be an unpublished opinion, it is persuasive. It's indicative of how the justices might be thinking, but it is not binding, as it would be binding if you had a first district case that was totally published and didn't have that limitation on it. Right. But there are still a number of cases that are considered to be Rule 23 summary orders. And those, unless you're the party involved, you might not even ever find those opinions.
Absolutely. Thank you, Your Honor. I appreciate your time.
Other questions? Got a minute left?
I hit the time mark there, Vita.
Yeah, you're good. You're good. Okay, well, if that's it, I'm just going to I want to thank Judge Finkel for a great presentation. And I'm going to start the poll. So asking everyone to stay on and finish this. So find where the poll.
And can I tell them about my sleep deprivation?
Yeah, sure. Go ahead.
This, for those of you who might know about domestic violence court, they have about once every 4 months, every judge has to do overnight duties. So this week, I'm doing overnight duties from 9 p.m. to 3 in the morning. So all week long, I'm up to 3 in the morning. And let me tell you, it does mess with your internal clock.
And still, he's just an awesome judge, no matter how tired he is.
Yes.
So thank you, everyone. I just want to stop the recording here.